Can Milagro Elizabeth Cooper file a dispositive motion now and realistically expect to succeed in Pete v. Cooper? The defamation and emotional distress lawsuit filed by Megan Pete, aka Megan Thee Stallion. Let's review what's happened so far. Motion to dismiss. Cooper has already filed a motion to dismiss for failure to state a claim back in late 2024. The court denied an earlier motion to dismiss as moot in December 2024, likely due to an amended complaint having been filed. Case status as of August 1st, 2025. The case is actively proceeding, with depositions being enforced. The court ordered Tory Lanez, referred to as Mr. Peterson, to pay attorney's fees and mandated continuity of his deposition. Pretrial motions, including in limine motions, were due June 24th, 2025, and general motions were due May 27th, 2025. Legal findings. A judge has already ruled that Megan Pete's amended complaint sufficiently pleads defamation and intentional infliction of emotional distress, IAD claims, allowing both to continue past the pleading stage. Can Cooper still file a dispositive motion? Technically, yes, but timing is critical. The typical window for dispositive motions, e.g., summary judgment, has likely passed, given that the filing deadline was May 27, 2025. If Cooper missed that deadline, the court is unlikely to permit a late dispositive motion without extraordinary justification. Can Cooper still file a dispositive motion? Technically, yes, but timing is critical. The typical window for dispositive motions, e.g., summary judgment, has likely passed, given that the filing deadline was May 27, 2025. If Cooper missed that deadline, the court is unlikely to permit a late dispositive motion without extraordinary justification. If Cooper could still file, would she win? Defamation. The court has already held that the allegations, such as circulating deepfake imagery, false statements about Megan's credibility, mental state, and substance use, are sufficiently factual false and made with reckless disregard to survive a motion to dismiss. IIED. The court also found that, given Megan's trauma from a violent crime, the alleged conduct could be considered extreme and outrageous, and that at this early stage, it's too premature to dismiss without a factual record. These findings make it unlikely a dispositive motion will succeed, at least on the existing pleadings and record. Bottom line, can she file one now? Unlikely, given that motion deadlines have passed. Could it win? Doubtful, if the court maintains its earlier rulings that the case can proceed on both defamation and IAD. If Cooper's team believes there are new, compelling legal grounds or evidence to warrant reconsideration, they would need to seek the court's leave to file out of time, and even then, success is far from sure. Let's break this down into two parts. Whether Milagro Elizabeth Cooper could realistically get an extension to file a dispositive motion until August 28, 2025. What potential legal grounds she could raise if allowed to file. Extension request feasibility. Federal courts. This case is in the Southern District of Florida. Follow Rule 6B of the Federal Rules of Civil Procedure for deadline extensions. Before the deadline passes, you only need good cause to get an extension. After the deadline passes, you need good cause and show excusable neglect. Since the dispositive motion deadline, May 27, 2025, has already passed, Cooper would have to prove excusable neglect. Courts typically look at four factors, from Pioneer INV. Serves. Company v. Brunswick Essex, 507 U.S. 380, 1993. Danger of prejudice to the opposing party. Megan Pete's side will likely argue prejudice because discovery and pretrial work are already done. Length of delay and its impact 3 months after the deadline is significant. Reason for delay. Lack of counsel can be a reason, but courts are skeptical because parties are still responsible for meeting deadlines even without a lawyer. Good faith. Whether the delay was intentional or tactical. Translation. The no lawyer reason isn't automatically excusable neglect, especially in federal court. She would have to show she was actively trying to secure counsel and that her inability to file was truly unavoidable. Potential grounds for a late dispositive motion. If the court grants an extension and allows a dispositive motion, like summary judgment, Cooper could argue a defamation claim weaknesses. Truth defense as she can prove her statements were substantially true. Opinion defense statements framed as opinions rather than factual assertions, but court has already found many were factual enough to survive dismissal. No actual malice since Megan Pete is a public figure. Cooper would need to show she did not act with knowledge of falsity or reckless disregard for truth. No damages argue Megan hasn't proven actual, quantifiable damages linked to Cooper's statements. Be intentional infliction of emotional distress. Not extreme outrageous enough argue that the conduct, even if rude or offensive, doesn't meet the high legal threshold for extreme and outrageous behavior. No severe distress point to lack of medical records, therapy, or other proof of severe emotional harm. Realistic outlook. The judge has already ruled that Megan's claims are legally sufficient to proceed. Summary judgment motions succeed only when no reasonable jury could find for the other side based on the evidence. Given the court's earlier rulings and the stage of the case, the odds are low, but not zero, if Cooper can present strong factual evidence, truth, lack of malice, lack of damages. Milagro's team could frame the excusable neglect argument, so it has the best shot at getting the August 28, 2025 extension approved. That's the critical first step before even talking about winning the motion. Here's how Milagro Elizabeth Cooper's side could frame an excusable neglect argument to maximize her chances of getting the court to extend the dispositive motion deadline to August 28, 2025. Step 1. Acknowledge the deadline and miss filing. Show the court you're being transparent and not trying to hide the fact the May 27, 2025 dispositive motion deadline passed. State upfront that you understand the court's scheduling order and that you're making this request under Rule 6(b)(1)(b) after deadline extensions for excusable neglect. Step 2. Emphasize continuous good faith efforts. Courts punish parties who look like they sat on their hands. To avoid that, Milagro's motion should document timeline of losing and replacing counsel, exact date prior counsel withdrew, efforts to retain new counsel, emails, calls, meetings, delays caused by vetting lawyers and fee negotiations, steps taken during the gap, any self-representation attempts, drafting, research, filing of procedural documents pro se, if any, attempts to keep up with discovery despite not having a lawyer. Step 3. Tie delay directly to lack of counsel. The no lawyer reason only works if it was the direct and unavoidable cause of missing the deadline. Argue that because dispositive motions require complex legal drafting, she could not adequately prepare one without counsel. Stress that she did not delay for tactical advantage. The delay was forced by circumstances. Step 4. Address each pioneer factor. 1. Prejudice to opposing party. Say Pete's side will suffer minimal prejudice because trial has not yet started. Allowing the motion could even narrow or resolve issues before trial. Evidence has already been exchanged in discovery. 2. Length of delay. Admit it's about 3 months late, but frame it as short compared to total case length, which started in 2024. Say you move for extension as soon as possible after securing counsel. 3. Reason for delay. Stress lack of legal training plus inability to prepare motion while pro se. Highlight the necessity of professional legal assistance for a dispositive motion. 4. Good faith. Show no history of missed deadlines or bad faith delay tactics. Attach any correspondence proving diligence in securing counsel. Step 5. Offer a compromise. Courts like when you make the request less burdensome. Offer to file the dispositive motion earlier than August 28th if possible. Agree to adjust trial deadlines if needed. State willingness to limit arguments in the dispositive motion to those already supported by existing evidence. Sample framing sentence. Defendant Cooper respectfully requests an extension of the dispositive motion deadline to August 28, 2025, pursuant to Fed R104, P6(b)(1)(b) on the grounds of excusable neglect. The delay was caused by a loss of legal representation shortly before the original dispositive motion deadline and diligent but time-consuming efforts to secure replacement counsel. Defendant acted in good faith throughout, promptly sought this extension once new counsel was retained, and granting this request will not materially prejudice plaintiff given that discovery is closed and trial has not yet commenced. Overall, what is the percentage of Milagro winning the dispositive motion? Given the court's history in Pete v. Cooper, the procedural posture, and what's already been decided, the odds are not great for Milagro Elizabeth Cooper to win a dispositive motion even if she gets an extension. Here's why. Court already ruled the case survives dismissal. In February 2025, the judge found Megan Pete's claims for defamation and IAD were strong enough to go forward, meaning the legal foundation has already been tested and upheld. Summary judgment standard is high. At this stage, Cooper would have to prove there is no genuine dispute of material fact and that she's entitled to judgment as a matter of law. In defamation cases, That's rare, because intent, truth, and damages are fact-heavy issues usually decided by a jury. Timing, asking to file late, is already a hurdle, and the court may not want to reopen pretrial issues this close to trial. Bar chart, estimated probability, based on similar federal defamation cases in the Southern District of Florida. Getting extension to file 30 to 40% chance, depends on strength of excusable neglect showing. Winning the dispositive motion if allowed to file 10 to 15% chance. Overall chance of winning dispositive motion from where she is now around 3 to 6%. In other words, possible, but the odds are firmly against her unless she has new, strong factual evidence that destroys key elements of Megan P's claims.